Having reached a conclusion that the legal foundation of the charges was shaken by that misclassification, the court concludes that the prosecution has failed to persuade this court beyond reasonable doubt that the subject procurement process was a tender, as asserted. I now embark on the analysis of the principal question, of course, proceeding on this footing that the process was a pre-qualification. In the recent submissions, it is the prosecution's case that the tender opening process was not complied with, contending that the law, namely Section 78 of the PPADA, requires a minimum of 3 members of tender opening committee, but only 2 members participated. The state argues that the opening of the tender was not properly done and that the 8th and 9th accused persons were not bound. The state argues that the accused persons took a position, the accused persons took a position that being a pre-qualification process, the law on opening tenders does not apply, and the 8th and 9th accused persons were not bound by the requirements of Section 78 of the PPADA on opening of tenders. In refuting the defense position, the state argues that once the accounting officer brought the organization within the ambit of the law, the appointees were duty-bound to comply with the law, placing reliance upon Section 78(1)(a), subsection 9, and subsection 10, PPADA on opening of tenders. The tender opening minutes exhibited as prosecution exhibit 3, the testimony of PW3, that is David Mwachi Mackenzie, and the testimony of PW1, Awings Kodek. In this connection, this court is asked to find the 8th and 9th accused persons failed to comply with the law relating to procurement. From the onset, it should be in clear context that in seeking approval of the nominated members of the opening committee, in his memo to the MD, the GM supply chain, PW6, expressly cited and placed reliance upon Section 78, 1 and 2 of the PPADA. And for this, see prosecution exhibit 4, paragraph 1. In response, and in approving the request contained in prosecution exhibit 4, the MD addressed a memo to the GM supply chain, exhibited as prosecution exhibit 5. And so it becomes necessary to satisfy myself whether Section 78 of the PPADA applies to pre-qualifications. The fact that the applications for pre-qualifications were opened by 2 members is not contested by the 8th and 9th accused persons. The crux of the 8th and 9th accused persons contest is that they are not bound by the requirements of Section 78 of the PPADA on opening tenders in its entirety. I have set out the provisions of Section 78. I will not read for context purposes. I will go to the conclusion. It is discernible from Section 78 of the PPADA, and the prosecution did not attempt to rebut this position, that the section properly so applies to tenders and not pre-qualifications. The relevant provisions which govern pre-qualifications are enacted under sections 93 through section 95 of the PPADA. While under sections 93 to 95, this court conscientiously searched for a provision which makes provision for a tender opening committee and I found none. While at it, that is under sections 93 to 95, this court also conscientiously searched for provision which prescribes the quorum for tender opening committee in courts, and this court found none. In any event, prosecution witnesses, in particular prosecution witness number 8 from PPRA, while under cross-examination, did admit that the relevant provisions of law which apply to pre-qualifications are 93 to 95. And that since there is no provision that makes provision for the minimum quorum, clause 3.4 of the procurement manual for works applies. In summation, this court finds and so concludes that number one, the 8th and 9th accused persons participated in opening applications in respect to qualification of tenderers. Number two, that the PPADA has no provision for mandatory requirement of opening applications for pre-qualification of tenderers. Number three, that the PPADA does not therefore prescribe a quorum for opening applications for pre-qualification of tenderers. Number four, that section 78 of the PPADA, including the requirement of quorum, which is ingrained in that section, does not apply to pre-qualifications. In the premise, this court reaches a conclusion that ab initio there was a serious misapprehension of the PPADA which triggered a fatal legal domino effect. The said misapprehension of the PPADA led to a serious misdirection in law, and specifically respect to the fundamental dissimilarities between a pre-qualification and a tender, which in turn led to the misclassification of the nature of the opening, which was undertaken by the 8th and 9th accused persons, and the nature of the evaluation, which was undertaken by the 4th, 6th, and 7th accused persons, which in turn further led to the misapplication of the law, which led to the charges on record, which are divorced from the factual matrix of the case, rendering them deficient of legal and factual precision of the military required of proper charges. The test of fatality defective charges is both substantive and procedural. But principles have underlined that the substantive element of charges is fatal, while the procedural element of charges is formalistic and not necessarily fatal. It follows the evidence and the facts in support of the charge indicted in count 4 does not in total disclose an offense on the part of the 8th and 9th accused persons. It bears repeating, in summary, because the 8th and 9th accused persons were not bound to comply with Section 78 of the PPADA. Consequently, this prosecution the court reaches the inevitable conclusion that the prosecution has failed to prove beyond reasonable doubt that the 8th and 9th accused persons failed to comply with the law relating to procurement, and in particular Section 78 of the PPADA, in their capacity as members of the tender opening committee. In relation to the necessary question whether the payments were fraudulent, therefore, none of the prosecution evidence was incriminatory. Instead, the totality of the prosecution evidence converged at the point that there was payment for work done and that there was value for money, translating the evidence in relation to the fraudulent payment asserted by the prosecution was exculpatory. In further connection to the foregoing, although the particulars alleged fraudulent, improper, and unlawful payments to the contractors, the said sum, the named prosecution witnesses who are in charge of processing the payments presented evidence which was at variance with the particulars of the charge. No material evidence has been placed before the court to assist the court in drawing an inference, if any, of a meeting of the mind to commit an offense of corruption or economic crime in that regard. It is an established principle of criminal law that in circumstances where facts and or evidence presented by the prosecution is locked in conflict with the charges in a manner that the facts and or evidence do not support the particulars of the charge, the accused is entitled to an acquittal.